further ado, I will send it over to Professor Klug for this final panel, the University of Wisconsin Law School on Constitutionalism and Democracy.
Thank you very much. And I want to thank Abigail Chase and Connor Clegg for all the work they've done for the symposium, and for all my colleagues and Professor Tashney for joining us this afternoon. So the symposium has focused on the intellectual history and tradition of the University of Wisconsin Law School. And this panel on like that, previous panels are long-standing traditions and intellectual traditions at the law school. And the argument that we're making with this panel today, that is in fact constitutionalism and democracy is a tradition, intellectual tradition of the law school, and one that has come into its own more recently, particularly with the Wisconsin Discussion Group on Constitutionalism, commonly called the Wisconsin Schmooze, the Conlaw Schmooze, which happens on an annual basis now. And so I think that what we're able to present this afternoon is a real broad overview of the kind of tradition in constitutionalism, democracy that the school has had for quite some time, and bring it together so people can actually see it as that. I'll begin briefly by just giving a brief introduction of our panelists this afternoon, and then we'll hand it over to them. So the first panelist this afternoon will be, and this will be the order, will be Professor Richard Minette, who's Professor of Law at the University of Wisconsin Law School, and he'll be talking on conquest by, and in brackets, state citizenship, federal Indian law, Native Americans, and voting rights. He'll be followed by Professor Linda Greene, who's the Ed New Bascom Professor of Law, and she'll be talking about Beyond George Floyd, Reparations for Past and Present Structural Racism. She'll be followed then by Professor David Schwartz, who is going to talk about law in action and constitutional history. And then finally, in that pattern, Professor Robert Yablon, Associate Professor of Law, will talk about the gerrymandering of constitutional structure. And finally, Professor Mark Tushnet, who's the William Nelson Cromwell Professor of Law Emeritus at Harvard Law School, and who began his career here at the University of Wisconsin Law School, will talk about legal process and constitutional law at Wisconsin. So I'm very excited to have this panel here today. And Richard, over to you for the first 10 minutes.
Sure. Thank you very much. Can you all hear me fine? A little nod? Yep. Okay. Very good. So also thank you, Abby and Connor and the Wisconsin Law Review members for doing this great event. I'm going to talk about, at first I kind of wanted to talk about the constitutions that our law school and many of our students have participated in drafting for a lot of the indigenous peoples. But we have a more pressing issue, and so I'm turning my attention to this paper instead. It's a little bit of counterintuitive, like federal law and Indian tribes can be. As Heinz said, the title is Conquest by State Citizenship. And I'm going to try to basically read so I don't go off on the hundreds of tangents that I think you'll probably agree are possible to go off here. I'm going to start with a quote from Chief Justice Marshall, probably not advisable in a succinctly timed event, but it is central to the discussion. The title by conquest is acquired and maintained by force. Humanity, however, acting on public opinion, has established as a general rule that the conquered shall not be wantonly oppressed, and that their conditions shall remain as eligible as is compatible with the objects of the conquest. Most usually, they are incorporated with the victorious nation and become subjects or citizens of the government with which they are connected. The new and the old members of the society mingle with each other. The distinction between them is gradually lost, and they make one people. So the Indian tribes, as they are unredoubtably labeled in the US Constitution, are again facing an existential threat. And this time their usual enemies have found some unexpected allies, the natives themselves. Many Native Americans seem bent on hastening the Chief Justice's premonition by blurring or or wholly obviating the distinction between them and state citizenries. Now, once upon a time, the Indian tribes fought and died for their separate existence from the several American states. In a later opinion, in fact, in Worcester versus Georgia, Marshall wrote, all these acts manifestly consider the several Indian nations as distinct political communities having territorial boundaries within which their authority is exclusive. Well, since those early days, the process of becoming citizens and subjects of the government has had some collateral casualties, including cultural differences between the native societies and those societies of the surrounding states. But my major theme here is, in the end, state citizenship for reservation-based natives, including civic participation and voting for or holding state office, will be the final nail in the coffin for tribal sovereignty. At the outset, the prevailing discourse, both formal and informal, dictates that two things be made crystal clear. This paper will not focus on national or American citizenship, but only on state citizenship. Moreover, the paper focuses on natives who reside within their native nation territory, not those without. On the former point, in 1924, one catch-all federal law purported to make all Native Americans into citizens. On the latter point, Native Americans living outside their respective reservations are now citizens of the states where they reside. So again, the focus here is on only state citizenship of reservation-based natives. The United States Court of Appeals for the Ninth Circuit rendered the most recent salvo, last week in fact, holding against Navajo Nation residents challenging Arizona's mail-in election processes. Of course, my ulterior point here is that citizens of the Navajo Nation would even contemplate such a lawsuit, let alone bring it. In 2018, election cycle also produced a slew of activity. A US Senate bill proposed the Native American Voting Rights Act of 2018 with support from Native nations and Native organizations. Meanwhile, the United States Supreme Court and the Eighth Circuit sort of went back and forth on North Dakota's voting law requirements, indirectly testing the political identity of reservation-based natives. On the other hand, some states actually facilitate native voting in state elections in disregard of reservation boundaries, which gives a little bit of hint of what I think about that. State elections are witnessing a dramatic increase of Native American candidates and office holders, including reservation-based candidates for state political office. So the US Constitution touches and concerns the Indian tribes in three separate clauses: apportionment, treaty, and commerce. The text, evolved doctrine, nor normative logic of these clauses support the conclusion that reservation resident Native Americans are citizens of the several states. Indeed, they require the opposite conclusion. The apportionment clause bases each state's representation in the House on the state's respective populations, but the clause includes a determinative phrase, excluding Indians not taxed, meaning, of course, reservation resident Indians, because they are not taxed by the states in any way. That same excluding phrase is also in the 14th Amendment, by the way. Consequently, the apportionment clause can only be read as making clear that reservation resident natives, at least, who are not taxed, are not state citizens and have none of the attendant civic rights and responsibilities in the several states. The Commerce Clause, every bit as ubiquitous in the federal-tribal relationship as in the federal-state relationship, is invoked as the source of Congress's authority or power to govern tribes in everything from gambling to child welfare to environmental regulation. But making them state citizens? That would require much more plenary power over both the states and the tribes than the clause contemplates. The Treaty Clause, while a tool of bringing of international relations, which of course the original US and tribal relations certainly were, nonetheless contemplates bringing separate sovereignties into the American federal orbit by treaty, as it did with Guam and Puerto Rico and Alaska and Texas. Indeed, this treaty federalism is the best way to cloak US tribal relations under the umbrellas of human rights and Republican democracy, even. Seemingly, a treaty could make reservation Indians, once citizens and subjects of independent sovereign nations, into the state's sovereign political orbit. So the question is, did any of them actually do this? The legal analysis is sparse, especially by natives themselves, straddling a continuum from collective to individual, from pure international sovereignty to wholesale subsumption into the American polity. A couple relatively recent titles tell the story. Professor Porter's The Demise of the Ongwehowe and the Rise of the Native Americans, Redressing the Genocidal Act of Forcing American Citizenship upon Indigenous Peoples. And then the retort by Professor Lavelle, Strengthening Tribal Sovereignty through Indian Participation in American Politics. Most importantly, for, again, my purposes here, while at opposite ends of the continuum, neither Porter nor Lavelle distinguish in any meaningful way between national and state citizenship. And it's a distinction that truly matters. Cohen's handbook, sort of the treatise in the field, Cohen's Handbook of Federal Indian Law, offers a revealing roadmap. The handbook's organization places citizenship in the chapter titled Civil Rights. In turn, Chapter 14's subheading pronounces Indians are US citizens, and a few subheadings later adds Indians as state citizens. Unabashedly, the chapter begins, Indians born into the United States are US citizens by birth. They are also citizens of the states in which they reside, because under the 14th Amendment, state citizenship derives from national citizenship. Evidently, the 14th Amendment's excluding Indians not taxed is an instance of constitutional fortuity to the handbook. A relatively recent book illustrates the new prevailing sentiment and articles as well. The book by Daniel McCool Olson Robinson is titled Native Vote, American Indians, the Voting Rights Act, and the Right to Vote. With an added dose of exquisite irony, here from the back to the Cohen Handbook, by the way, posits the single most problematic variable here in this analysis. It says many Indians are also citizens of Indian tribes, which are political bodies, making them dual citizens of both the US and the Indian nations, right? Well, entirely whiffing, I would say, on the fact that the handbook has just posited not a dual citizenship, but a tri-citizenship, national, state, and tribal, without explaining how that might work. This is not mere sophistry and semantics. In informal discussion with natives, I often encounter the retort, but we have dual citizenship. My response to those natives is that American law suggests not the separate polity that dual citizenship connotes, but at best some concoction of a federal citizenship, where your American and tribal civic identities overlap. However, laws derive from social, cultural norms and values. So it's one thing to imagine and even effect a symbiotic national and tribal citizenry with some overlap in norms and values. But when reservation-based Native peoples also participate in state polities, do we have three sets of applicable laws, which is to say, three sets of norms and values? So in conclusion, this prevailing civil rights analysis of federal Indian law and Native citizenship is the would-be narrative of a people on the outside looking in, trying to get in, to be treated equally, rather than of a separate people on the outside, trying to stay separate, to be treated differently. Participation by reservation-based natives will run headlong into America's revolutionary axiom, government by the governed. This new civic relationship between individual reservation natives and their surrounding states will be steeped in the dictates of mutual rights and responsibilities. America's revolutionary battle cry, no taxation without representation, will come full circle to be no representation without taxation, directed at Native state citizens. The Native nations and their own citizens, by donning their individual identity, are in the counterbalance, shunning their collective identity, and in the balance will be undermining their own sovereignty. That's it.
Thank you, Richard. Now over to Professor Greene.
Thank you. I really can segue from Professor Monette's discussion of citizenship for Native Americans to a discussion of the conditions under which Black Americans might ever realize full citizenship. I am talking about reparations, not only because reparations has long been a subject of discussion since General Sherman issued his field order number 15, containing the famous promise of 40 acres and a mule, which were never given to the former slaves. And since that time, the subject of reparations has come up time and time again. We probably don't think of Martin Luther King as someone who asked for reparations, but in his book, Why We Can't Wait, he said that African Americans deserve compensation for slavery, for segregation, and for discrimination. Obviously, that was not a center point of the movement. Black Americans were trying to be able to eat in a restaurant, attend a school, and also gain employment. And those concerns were lost in that very violent shuffle. This issue has come back again, in part as a result of the worldwide reaction to the murder of George Floyd. Now, it has never gone away. Congressman Conyers introduced a reparations bill in Congress for 30 years. And more recently, Sheila Jackson Lee of Texas also introduced a bill, and Senator Cory Booker of New Jersey also introduced a Senate counterpart. So what I want to do, my overall goal is to talk about the idea of equal citizenship and what would it mean to eradicate the structural disparities that exist that confine Black Americans to the lowest economic rung in our society, or one of the lowest economic rungs in our society. Our native indigenous people, of course, have been quite disadvantaged as well. But what would equal citizenship look like, and what might be the remedies or reparations that might restore or create for the next generation of Black Americans the prospect of the full enjoyment of equal citizenship in America? I want to talk about three possible examples of reparations, types of reparations, and I want to talk about a little bit about the actors. I won't, of course, be able to explain it in complete detail, but I'd like to talk about these three examples of reparations: reparations for mass incarceration, reparations for racialized police violence, and reparations for community disinvestment. Those are the three areas I want us to think about. And in each area, we need to think about who are the actors responsible, how did the discrimination actually operate, and what have been the harms. And if I'm not able to do that in detail for all three, then perhaps I can take some time later at the end. So what about reparations for mass incarceration? Mass incarceration is a common topic. We know a lot about that as a result of a lot of research. Here we have the federal, state, local governments, we have legislatures, we have courts, judges, private prisons, and others, all responsible for massive incarceration. It starts with the Black codes, which were designed to criminalize even the fact of being homeless was a matter of criminal law. So it starts with the Black codes, and then you can fast forward to today, where a Black person is 5 times more likely to be stopped without cause, while 1 out of every 3 Black boys today can expect to be sentenced to prison, compared to 1 out of 6 Latino boys, or 1 out of 17 white boys. Where 5% of the illicit drug users are African Americans, and yet there are 29% of those arrested and 33% of those incarcerated. We have a lot of information about mass incarceration today, especially with the effort to eliminate disenfranchisement. So what are the harms? The harms are at a community level. You're removing valuable assets from the community. You are affecting the capacity of the community. Social scientists have demonstrated that imprisoning many individuals from a single neighborhood adversely affects the entire neighborhood because of the cumulative effect of straining multiple social networks to which inmates belong. Sociologists have talked about this in terms of impeding the formation of social capital. And also social scientists have also theorized, based on social control research, that people who live in neighborhoods with high prison rates tend to feel a strong distrust of formal society. They have less obligation to obey the law, less confidence in the capacity of informal social control in their community. So this mass incarceration dramatically constrains the participation of African-American communities also in the mainstream political economy. And these are the invisible punishments that accompany a prison sentence. So in addressing these consequences to a community, this is a challenge to social scientists and others to begin to quantify the effects of mass incarceration. We know that mass incarceration affects families, that it deprives families of income, that it exposes those who are in prison to many forms of ill, including violence, illness, etc. But what are the community harms? So I'll stop there with mass enfranchisement. What about police brutality? Of course, very much on the front burner. And we know, of course, we've witnessed the harm or the murder of a number of people ourselves. So we know about that suffering and the suffering of their families. But what are the other harms? What are the psychological effects on communities as they witness or experience harassment, as they experience routine unwarranted searches, as they experience the fact that these deaths go unpunished? What does that say to the Black community about their citizenship? And what are the emotional and psychological losses that are attributed to that dismissal? Defending the character of loved ones after police have killed them is excruciating, and entire communities are caught up in this effort. We have the task of explaining to our non-Black friends, co-workers, and strangers the connection between structural racism and the latest police shooting. That is what we do every time a shooting occurs. People ask us to explain, do you think that that was warranted? Do you think that he deserved that? Do you think that because Mike Brown stole a cigarette from the store that he brought that on himself? That's the conversation, but that's a broader psychological burden that communities bear. There also the economic productivity. Economic productivity is lost, a time to plan and attend funerals. There's so much there. All right. There's more that I can say there, but I want to just go on to the community disinvestment. I just have a couple of minutes, but I wanted to have these ideas out because I not only on my panel are there some of the most brilliant thinkers in constitutional law, but also I know that in our audience, there are many people who care about these issues. Community disinvestment operates in many ways. Something people don't know, when President Roosevelt, Franklin Roosevelt was president, his administration created a homeowners loan corporation, which was created in 1932, and it undertook a major enterprise, the redlining of neighborhoods. The Homeowners Loan Corporation enacted race-motivated impairments by drawing color-coded maps documenting the so-called riskiness and lending across neighborhoods in over 200 cities. And the risk factors included a number of factors, but they also included race, ethnicity, and immigration status. And so entire communities were cut off from the opportunity to build wealth through home ownership. Entire neighborhoods were the object of disinvestment. And to the extent that certain neighborhoods were not able to have access to loans, those neighborhoods became less desirable, and many people fled those neighborhoods, including whites. Blockbusting, redlining, steering, racially restrictive covenants. But beyond that, we know about housing, but what about the wholesale disinvestment in the economic aspect of communities? And what have been those consequences? I think we are learning more about those consequences today because the anger that has spilled over from the police murder has made visible to us the conditions under which Black communities live, and some of those conditions are the result of these phenomena that I've discussed. So I will stop. This is a challenging project, but this is very much a part of the current discussion. We'll hear more and more about it. My last question is, will our constitutionally impoverished imagination expand to allow these remedies to permit Blacks to enjoy full citizenship? During Reconstruction, our equal citizenship aspirations were dashed against a constitution. So much so that when Congress passed the civil rights legislation, it could not go to the 14th Amendment Citizenship Clause. It had to use the Commerce Clause. So the question then is, as this aspiration for equal citizenship continues to grow, will we find our own Constitution once again a barrier to the dream of equal citizenship? And thank you for that extra minute, Heinz.
Thank you, Professor Greene, and over to Abigail for the.
Yes, we will be sharing the first passcode for CLE. The first passcode is century. So for all of the Wisconsin attorneys that have been with us for the last 2 days, we really appreciate it. The first passcode is century, and you can expect to hear the second passcode, part 2, after Q&A. Thank you. Off to Professor Schwartz.
Yes, thank you. Professor Schwartz.
I believe you're muted.
Yeah.
There we go.
Okay. Thanks for inviting me to participate in this fabulous panel. When I first came to Wisconsin, and for several years afterward, I didn't fully understand how the Wisconsin law in action tradition meshed with Wisconsin's other great tradition, that in legal history, a tradition that owed to the enduring legacy of the great Willard Hearst. One aspect of law in action is that legal doctrine is virtually never autonomous. It's not the product of pure reasoning of legal principles that stand apart from politics. And I think this is nowhere more true than in constitutional law. I've always tried to teach my students that the constitutional law decisions of the Supreme Court are not usually dictated by legal doctrine, at least when the case involves issues we care about. Maybe a decision on the constitutionality of mudguards on interstate trucks under the Dormant Commerce Clause is driven by doctrine. But constitutional decisions on voting rights, on free speech, racial equality, healthcare reform, abortion, and more are driven more by constitutional politics than by interpretive theories or neutral principles. This is not to say that all such Supreme Court decisions are political or that they're result-oriented or unprincipled. But it is to say that constitutional law is hammered out in the forge of political debate. And that's probably as it should be. The justices should think about the consequences of their decisions. And those consequences sound in constitutional politics, the political debates that shape the organization, the constitution of our society and our polity. What I've learned since embarking on my constitutional law teaching career at Wisconsin is that just like law is not created in a vacuum of abstract principles, and just like legal doctrine is shaped by constitutional politics, the constitutional politics of today did not exist in a vacuum or spring up yesterday. Constitutional politics is shaped by history. The constitutional politics of today is a point in a journey that's lasted over 2 centuries. So constitutional law is, in a very important sense, constitutional history. And I've finally come around to understand the legacy of Willard Hearst. Law is law in action, and law in action exists in historical time. So law is, in a very important sense, legal history. My research and teaching have turned decidedly toward constitutional history. The deep structure of the United States Constitution can't be fully understood without a deep dive into that history. I published a book last fall called The Spirit of the Constitution, which traced the 200-year history of how McCulloch versus Maryland was understood differently in different eras. And the argument of that book is that the potentially broad theory of implied powers which is kind of pure doctrine in a way, was blunted for more than a century by a Supreme Court that believed that its role was to advance a national constitutional project of protecting at first slavery and then protecting Jim Crow laws under the neutral sounding doctrines of federalism and states' rights. I've also tried to incorporate a significant historical content into teaching constitutional law. The standard doctrinal mode of teaching the con law course is based on an unspoken premise that constitutional law fundamentally began last June, the end of the Supreme Court's most recent term. We do teach older cases, of course, but only because they remain in the constitutional canon as of last June. That is, the current Supreme Court continues to find them to be important precedents. Yet con law also changes, and sometimes very rapidly or suddenly. And just to take one example from last June, the doctrine of presidential removal power, which had been the law and had been duly taught in Con Law 1 courses without much change for the past 30 years, is no longer good law because it was radically changed by the court this past spring. Moreover, an emphasis on present doctrine, when we couple it with reading the past through present doctrine, is highly misleading. It conveys an inaccurate, court-centered understanding about how constitutional law is made. It underestimates the influence that history continues to exert on present-day legal doctrine. And it falls short of Wisconsin's law and action tradition, which has always recognized the crucial role of history in legal development. Perhaps most importantly, I think only an immersive historical approach to constitutional law can adequately convey the extent to which issues of race are embedded in the deep structure of our Constitution. Our Con Law 2 course teaches the standard progression of Brown and Loving, from there to the affirmative action cases. But that really just skims the surface of these issues, as I think Professor Greene has shown us with the historical bent of her comments. Con Law 1, in Con Law 1, only a deep dive into founding era, antebellum, and late 19th century history can really convey the degree to which race issues are baked into the structure of federalism, even today. But this deep dive is simply not possible in a general Con Law 1 or 2 course, given the need to cover present day doctrine. So the current Con Law curriculum that we have is caught between two fires. On the one hand, our ability to teach historical material in the standard Con Law 1 and 2 sequence is limited. Students tend to find it at best interesting background if you go into history, and at worst a digression from what they really need to know. On the other hand, the demand for Con Law courses emphasizing where the law is now just can't be dismissed and replaced with a, we're going to teach you history whether you like it or not because it's good for you. There's a place for both, but they can't be competently done in the existing Con Law 1 and 2 sequence. And for that reason, I've actually tried to initiate a proposal to teach a new course on US constitutional history and have it embraced by the law school by counting it toward the 6-credit constitutional law requirement that we now have. Legal history as a subject is considered a luxury, and an unaffordable luxury in today's lean academic times. We don't have a full-time instructor of legal history on our faculty, and we haven't had one for over a decade. We don't currently have a course on American legal history in our curriculum. So maybe a constitutional history course endorsed by the law school by making it count toward the 6 credits on constitutional law that we now require would at least be a good place to start. Our law in action legal history tradition tells us that we need to look into our past in order to understand our present and to anticipate our future. Thanks.
David, thank you very much. To Professor Yablon.
Thank you, Heinz. Thank you to the Wisconsin Law Review and to Abby and Connor for helping to organize this event. Hello to my invisible audience. I am picturing all of you perched on the edge of your seats. The project that I'm going to be discussing today remains very much in the works, but I couldn't resist presenting it now as we hurtle toward both a presidential election and a Supreme Court confirmation. And in some ways, it follows nicely on David's comments because it is really an account of our modern constitutional politics. My thesis is fairly straightforward. The Supreme Court has increasingly come to embrace a warped vision of the Constitution's structure, one that shows insufficient regard for the document's democratic foundations. In recent years, as the court has shifted to the right, it has unabashedly advocated robust enforcement of federalism and the separation of powers, while simultaneously writing itself out of the law of democracy. In other words, the court has preoccupied itself with two sets of constitutional relationships between state and federal authorities, and between the federal government's three branches, while neglecting a third relationship, namely the relationship between the people and those who exercise governmental authority in their name. We've seen a vivid manifestation of this vision in recent weeks. On a near daily basis, the Supreme Court has refused to allow accommodations for voters impacted by the pandemic, and it has justified its inaction partly on federalism grounds. And every indication is that the court will further implement its contorted structural blueprint in the years ahead. So let me begin by describing some key features of the court's recent federalism and separation of powers jurisprudence, then contrasting that jurisprudence with the court's recent handling of democracy-related matters. Then, having juxtaposed those two lines of authority, I'll explain why I think they are, in fact, seriously incongruous. And finally, I'll briefly identify some seemingly more coherent alternative approaches and offer a cynical word on why the court may have chosen the path that it has. So first, consider a few examples of how the court has leaned in when presented with claims that certain policies or arrangements violate federalism or separation of powers principles. With respect to federalism, a majority of the court held in NFIB versus Sebelius that the Affordable Care Act exceeded Congress's Commerce Clause powers, improperly shifting authority away from the states and toward the federal government. In Shelby County versus Holder, the court nullified the pre-clearance formula of the Voting Rights Act on grounds that it exceeded Congress's powers and offended notions of equal state sovereignty. With respect to the separation of powers, the court last term in Saylor Law versus Consumer Financial Protection Bureau served up some unitary executive theory to hold that the CFPB could not lawfully operate as an independent agency led by a single administrator. A majority of the court also seems poised at the next available opportunity to reinvigorate the non-delegation doctrine. Decisions like these share three salient features. First, the court is eager to opine on the Constitution's grand design. The justices think big. They offer a holistic account that treats text, context, and overarching purposes. They describe a system that divides and distributes power vertically and horizontally in order to safeguard liberty and promote accountability. Second, the court does not hesitate to deploy these big picture design principles to resolve particular controversies. The justices are willing to develop specific doctrines to operationalize general concepts. In NFIB versus Sebelius, Justice Scalia drew a straight line from the notion that the framers fragmented governmental power to protect liberty to the conclusion that Congress cannot regulate the failure to buy health insurance. In Saylor Law, the court leapt from Article 2's instruction that the president take care that the laws be faithfully executed to the conclusion that Congress cannot establish a federal agency headed by a single administrator who is removable only for cause. Third, the court in these cases accepts the centrality of its own role. The court does not trust other actors in the system to maintain acceptable federal, state, or interbranch relations on their own. The justices express concern that actors might seek to aggrandize themselves or hamstring other institutional players. As they see it, active judicial policing provides an indispensable check. As Justice Scalia put it in NFIB versus Sebelius, it is, quote, the responsibility of the court to remind our people that the framers considered structural protections of freedom the most important ones. Well, when the court confronts democracy-related matters, its approach could hardly be more different. Again, consider a few examples beyond the orders that the court has been issuing in recent weeks. In Shelby County, the court had more to say about federalism and its implications for the Voting Rights Act than about the act's significance as a safeguard for democratic participation. In Rucho versus Common Cause, the court held that partisan gerrymandering claims are categorically non-justiciable. And views that until now have been confined to concurrences and dissents may soon find themselves commanding majority support. And that includes Justice Thomas's skeptical view of the foundational one-person, one-vote doctrine that he expressed in Evanwell versus Abbott. In other words, the same justices who energetically construct constitutional meaning when it comes to federalism and the separation of powers somehow find themselves wholly unable to do so when it comes to democracy. The same justices who readily leap from the general to the specific in federalism and separation of powers cases insist that they can discern no operative rules in cases involving democratic representation. The same justices who view the courts as indispensable guardians against perceived affronts to federalism and the separation of powers unceremoniously abandon the field when asked to secure democratic rights. I would suggest that this is a striking disconnect. Many commentators, of course, have critiqued the court's recent work in each of these individual domains, federalism, the separation of powers, the law of democracy, but I think placing the court's sensibilities in these areas side by side adds a new dimension to these critiques and places a new burden on defenders of what we might call the court's conservative structural orthodoxy. Justifications for the court's rulings that may seem reasonable in isolation may ring hollow when placed in comparative relief. For example, is it plausible that constitutional generalities about executive power apparently suffice to establish the impropriety of for-cause removal protections for single-headed agencies, but yet the Constitution is indifferent to even the most extreme partisan gerrymanders? Is it plausible to think that liberty and accountability are more at risk when the executive and legislative branches agree to a for-cause removal limitation than when partisan actors manipulate district lines to insulate themselves from any realistic prospect of electoral defeat? The court often articulates democratic rationales for its federalism and separation of powers decisions, such as a desire for government actors to remain responsive to the people. Well, if these professions of democratic concern are real, it is difficult to understand why they fall by the wayside in cases where democracy is truly front and center. Justice Kagan put it this way in her dissent from the court's decision in Rucho to pass the buck on partisan gerrymandering, quote, "Of all times to abandon the court's duty to declare the law, this was not the one." Now, I suppose a defender of the court and its conservative structural orthodoxy could argue that the Constitution simply has less to say about democracy than about federalism and the separation of powers. But that is doubtful. Neither federalism nor the separation of powers appear in the Constitution by name. They are constructs. And the building blocks of a foundational democratic principle are at least as prominent in the document, especially with the additions of the Bill of Rights and the 14th, 15th, 17th, 19th, 23rd, 24th, and 26th Amendments. The Constitution plainly does more than establish a system in which states check the national government and the branches of the national government check each other. It also establishes a system of popular sovereignty in which the people, through various channels of democratic participation, guard against abuses of governmental power, and as described in the preamble, work collectively to secure the blessings of liberty. Indeed, James Madison described the Constitution's vertical and horizontal divisions of power as, quote, auxiliary precautions. The, quote, primary control on government was a dependence on the people. The court's structural orthodoxy seems to distort the Constitution by giving primacy to the auxiliary while relegating the primary to the periphery. And along the way, the court misses one of the primary reasons why the separation of powers and federalism exist. The court sometimes casts those structural features purely in libertarian terms as devices for constraining government action. But in reality, they also serve as important mechanisms for making our system of government more participatory and our democratic deliberations more robust. As I see it, the court ultimately has four basic options for how it approaches federalism and separation of powers questions on the one hand and democratic-related questions on the other. First, it could take a hands-off approach in both domains. Second, it could take a hands-on approach in both domains. Third, it could be hands-on with respect to democracy and hands-off with respect to federalism and separation of powers. Or fourth, it can do what it has done, be hands-on with respect to separation of powers and federalism and hands-off on matters of democracy. Sitting here today, my sense is that the court has settled on the least defensible of these four options. Options 1 and 2 at least have a stronger immediate claim on consistency. And option 3 has much to recommend it, especially if we accept Madison's notion of which controls are primary and which are auxiliary. The better our democracy functions, the less need there may be for judges to second guess the decisions of elected officials about how to allocate authority vertically and horizontally. So why option 4? I don't want to psychoanalyze the justices or impute motives to them, but the one obvious advantage of that option is that it seems to produce outcomes that align most closely with a certain set of partisan preferences and interests. And to the extent that the court's divergent approaches to federalism and the separation of powers on the one hand, and to democracy on the other, do serve to tilt the scales in a particular direction, the court isn't just making an analytical error, it is gerrymandering the Constitution's structure. So I'll leave it there.
Thank you very much, Rob. Now we go over to our final panelist, Professor Tashney. Thank you.
Thank you. I am pleased to be on this panel. As Professor Klug noted, I started my teaching career at Wisconsin, and I really regret being unable to be in Madison during the best season for Madison, at least from my point of view, the autumn. I'm going to try to extract sort of 3 themes from both my understanding of the tradition of constitutional law at Wisconsin and the comments that have been made before. The 3 themes are, just to label them, legal process, legal consciousness, and law in action. I want to begin, though, with a personal anecdote. When I was in law school, I served one summer as a research assistant to Professor Boris Bitker, a great tax professor, one of whose daughters actually attended the University of Wisconsin Law School. He was then writing a book ultimately published as The Case for Black Reparations. And he asked me to do some research about the Indian Claims Commission as a form of, in some sense, reparations. As I set about that task, it seemed to me appropriate, maybe it was idiosyncratic, that I should read up on the idea of legal process. So I spent a couple of weeks reading the course materials called The Legal Process by Hart and Sachs at Harvard Law School. Now, what was the point of the legal process idea? Well, first of all, I want to note that there was a set of legal process materials published by Wisconsin law professors, Auerbach, Garrison, Hurst, and Mermin. For a variety of reasons, it was not as successful as the Harvard materials. At one level, it was better conceptualized than the Harvard materials. At another level, it probably wasn't, but Wisconsin was not Harvard, and that's almost certainly what was the dispositive factor in the reception of the materials. I would also note that Willard Hurst's great book on the lumber industry in Wisconsin was all about a legal process perspective on, in that instance, the governance of an extremely important economic institution. So what was the idea of legal process? Well, for our purposes and for limited time, the basic idea was that you wanted to focus on the way different institutions of governance deal with problems of governance in a democracy. How do you organize the institutions that we have or might have so as to promote the values of democratic governance? And the materials examine private law as a mode of governance, what we now think of as regulation as a mode of governance, and constitutional law as a mode of governance, sort of regulating the regulators. I don't want to go into detail about the arguments that were embedded in these works in the legal process idea. It's the idea that you pay attention to institutions and how they interrelate. In some ways, I think we could read Professor Yablon's comments in legal process terms. For my purposes, I think it's important to focus for now on what do we mean when we refer to institutions. Now, at some level, we have some sort of ground level understanding. The Supreme Court's an institution, the Wisconsin legislature is an institution, the Wisconsin state courts that apply tort law are institutions. But when you try to get a more precise handle on the idea of institutions, and particularly in the 1950s when these materials were being produced, it turns out that the prevailing idea about how you define an institution was roughly like this. Institutions are patterns of behavior according to shared beliefs. And what that means is that beliefs, both about what the institutions in some sense are and about how they should operate, what makes a legislature rather than a court, or what makes something a statute rather than a constitution. It turns out that those distinctions rest centrally on widely shared beliefs. So that leads to the second category that I have, which is legal consciousness. And again, in the Wisconsin tradition, that's embedded in Hearst's great book on law and the conditions of freedom, which is about the culture of belief about legality for him in that book in the 19th century. But for the legal process thinking, you would think about legal consciousness at every moment that you're dealing with it. Again, in some ways that echoes Professor Schwartz's concern about or interest in bringing historical understanding to contemporary issues, because the underlying structures of how we think about things, they were important then. Seeing how those structures worked then can help us understand how our contemporary legal consciousness is shaped today. And then finally, there's the law and action theme. And here, I think that most of that in the Wisconsin tradition came through the Wisconsin political science department into the law school, rather than being a product of constitutional thinking within the law school. So again, I started teaching in 1973. Joel Grossman was in the political science department, and he was I don't know what the right word is, resource person or influence who made sure that when Wisconsin constitutional lawyers thought about constitutional law, they would also think about the Constitution as a vehicle for the exercise of political power, both in doctrine, which is the legal consciousness version of this, and on the ground. And so when you put all these things together, I think maybe this is just a defense of the way I ended up doing constitutional law, having been shaped at Wisconsin. I think that what we have, what Wisconsin gave the field of constitutional law was a very powerful set of tools to think about constitutional law, meaning in important ways, constitutional doctrine, as both a mode of implementing, enforcing power in the ordinary sense, and as a mode of cultural expression, which is another mode of exercising power. And I'll just conclude on this for myself. The comments that Professor Monette and Professor Greene made fit for me into that latter set of concerns. That is, constitutional law as embodying ways of thinking about governance and relations among people and peoples that are expressions of the culture in place or the consciousness in place at the time we're interested in. Thank you.